Hi, Stefano Molea here, San Diego criminal defense lawyer and partner at the law office of David P. Shapiro, where we help good people regain control of their future when charged with a crime. In this video, I want to talk to you a little bit about some things for you to know if you have a criminal defense lawyer, whether it's a privately retained attorney or whether it's a public defender. Some things for you to know and be aware of to make sure that you put yourself in the best possible position within your case, right? Ultimately, it's your case. It's your future, it's your freedom that are at stake. And so it's your job to stay on top of it, right? Now, obviously, you're gonna take the advice and you're gonna have conversations with your attorney and take their legal counsel. But there are some times where you may be more willing to be proactive than what the attorney may assume. And so it's very important for you guys to be on the same page. So let me give you an example. Let's say that you've hired a lawyer, and it's for maybe a drug case, or maybe it's a DUI of some sort, or maybe it's a violent crime, a domestic violence case, but there may be underlying concerns about maybe an unhealthy relationship with alcohol or other drugs. And you're just kind of sitting around waiting for the next court date, but you're not engaging in any kind of proactive treatment or getting yourself into classes or anything like that. And you may be thinking, well, why would I do that? My lawyer hasn't asked me to do that. Look, it may not be the right call for your case, but it's something for you to ask your lawyer about. It's something for you to have a conversation about and say, hey, do you think I should maybe be doing something a little bit proactive? Right? Should I maybe, just be prepared by taking these classes, by going to AA meetings, by taking, counseling? And one thing I want to make a note about is that just because you're taking, let's say, AA meetings, or you're going to AA meetings, or you're taking a class on domestic violence, it does not mean that you're making any kind of admission just by taking the class that there's a problem, that there's some issue that you need to address. I know it seems that way, and that's a reasonable sort of conclusion, but that's not how the prosecutors see it, right? And that's not how defense lawyers use it as a tool to essentially put our clients in a better position. A lot of times, regardless of whether or not somebody actually has a problem with alcohol, let's say, I will ask my clients to take AA meetings if the foundation of the case deals with alcohol. And this could be the very first time that the clients have ever consumed alcohol. But the reason why I do it is not because we're addressing a problem. It's to demonstrate that, one, the client's taking the case very seriously, is being proactive, and is demonstrating to the prosecution all these things. But also to give the prosecution some comfort that they can put in their file, right? Some paper trail that they can put in their file, so that if your lawyer is able to negotiate, if I'm able to negotiate a better outcome than maybe the average result, the prosecution has to kind of show why, right? They have to have a paper trail of why they did what they did and why they gave maybe an offer or resolution to a client that's better than the average. And so they have to be able to document it. And so that's what, doing AA meetings or doing counseling allows you to potentially do. Okay. So again, we don't know whether a counseling or treatment is right for you, but the point is that it's a conversation you should be having with your attorney as you make a decision about what's best for your case. Okay. Now, again, here's the interesting thing. There's two separate parts to a case, right? There is the mitigation side, which is sort of a safety net as I describe it. And then there is the legal technical side, right? Which is asserting defenses or, attacking the prosecution's ability to prove their case, okay? Those two are separate roads, but obviously they run parallel. You always, as a lawyer, you're always going to technically evaluate and assess and analyze the legal aspects of a case. And then, my job as your lawyer would be to explain it to you, have you understand it. And then from that analysis, we start identifying options, right? And the pros and the cons of the different options. But there may be situations where after you do all the analysis, you look at all the options, you determine that the best option may be a plea bargain. And if that's the case, you don't want to be way down the road into the case determining that you have to now try to go for a plea, and a favorable one at that, and have nothing to show for it. You've wasted all this time and you haven't done anything proactive in your case, and you haven't given your lawyer the tools necessary to be able to go to a prosecutor and say, here's why my client should get this outcome. Here's the support for it, right? So that's why I describe it as a safety net, is we don't know if we need it, but we definitely don't want to be caught without having those tools in case that's where we end up with your case. So hope this kind of gives you some perspective and some helpful information about programming and being proactive and what that really means and how that relates to fighting the case or not. If you have any questions or you want to chat about it more, obviously leave any questions in the comments. Otherwise, give us a call, 619-295-3555. Again, Stefano Molea, San Diego criminal defense lawyer and partner at the law of David P. Shapiro. Thanks for listening.